Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on the service matters. The judgment given by Madras High Court. It clearly says that when the competent forum, maybe the department or other thing, drops the charge memo or set aside the charge memo, suspension also will be set aside. When the charge memo is set aside, then you cannot continue the person under suspension for any more time. This is what is held by two judges bench of Madras High Court. Justice A.K. Jayashankaran Nambiar, A.K. Jayashankaran Nambiar and Muhammad Niyaz C.P. In the case of Matthew Joseph versus the Register of Cooperative Societies and others in writ appeal number 1473 by 2022 on 25/10/2022. In this case, the two judges bench clearly held that when once the charge memo which was given to the so-called delinquent, if it is set aside, the suspension also should be set aside and he has to be taken for duty. Because the main charge memo is dropped, then what is the fun of continuing him under suspension? No doubt. If you know the CCA rules, Code of Conduct and Appeal rules, you may be aware that suspension is not at all a punishment. But only thing is, you have to give subsistence allowance if he is kept under suspension for more than 6 months. Right? Now, let us go to the facts of the case. Right? So, the petitioner, Mr. Matthew Joseph, he worked as a paid secretary. Actually, in that Tamil Nadu, the area, they call him as a secretary. He worked as a secretary of Pudupadi Service Cooperative Bank Limited. He was working there. Then, without applying for leave, from August 2009 to August 2014, he absented from duty. So, for almost 5 years. And of course, the bank, actually, he wanted to rejoin in maybe 2013 or so, but he could not do because of his ailment. He was bedridden, asked to take rest for some more time. Therefore, he has taken some more time to rejoin in 2014. Right. Now, please remember, actually, a charge memo was given to him, or show cause notice was given to him for the unauthorized absence from 2011 to 2014 as per the Cooperative Societies Departmental rules. Of course, after getting the charge memo, during the inquiry, he proved that due to the sufficient reason or plausible explanation was given by him. Of course, he has gone in appeal before the arbitration court. It is what is called as the Registrar of Cooperatives. I'm sorry. So the Registrar of Cooperatives is acting as arbitrator. Ultimately, since he is the appellate authority, he set aside the charge memo. And actually all other proceedings were dropped. He has to be taken to duty. But the Cooperative Society once again gave a charge memo to him and suspended him. So, agreed by this, he has approached the Honorable High Court of Madras. Honorable High Court of Madras, this is where the so-called topic of res judicata comes into existence. He was previously suspended for unauthorized absence. Here, without taking permission. Of course, both of them convey the same meaning. But on the other ground, they have suspended him and once again they have given a charge memo. Therefore, he has approached the Honorable High Court of so-called Madras. So please remember, actually he also added, he had challenged that the suspension order, the period of suspension should be treated as on duty and he has to be paid the pay and allowance from 3/11/2011 or so, like that. Yes, I sure. So the single judge held that entire disciplinary proceedings are invalidated because already the main charge memo was dropped by the Registrar of Cooperative Societies. So what is the fun of once again giving another charge memo? Almost, no doubt it is a different thing, but almost on the same grounds. So whatever it is they have given. So the court ordered that conduct inquiry within 4 months and dispose the second charge memo. No doubt, since as per the department of proceedings you have given another charge memo and you have suspended him. Okay, release him immediately, conduct the inquiry or complete the inquiry within 4 months, and then only you can think of the next step. So what we have to know is, please remember, once the proceedings were invalidated, including the charge memo, suspension, no further suspension should be there. And naturally, the employee is liable to be paid the basic salary since it has been cleared. He has to be given the pay and allowance also. So very good judgment regarding service matters. So please see the case law of Matthew Joseph versus the Registrar of Cooperative Societies Limited and others in writ appeal number 1473 by 2022, decided by 2 judges bench of High Court of Madras, not Supreme Court. So if you know this much is sufficient. Thank you.